an application in the matter of CP and law and National Crime Agency.
Yes, can we start, please, with the issue of anonymity for the applicants? We understand that there was anonymisation in the proceedings below. All applicants ask for that to continue, and the respondent makes no strong submissions to the contrary. But could we just be clear, please? What power is the court being invited to exercise?
My Lord,
and on what basis? Thank you.
Could be, my Lord, I think the position may be slightly different from the information Your Lordship has been given.
Ah, right.
On the applicant's part, we have no objection to, we have no representations to make about anonymity at all. And so there is no positive submission on behalf of any of the applicants for anonymity to be continued. I understood that if there was an issue to be raised about it, Mr. Perry would deal with it, so I'm happy to hand over to him, but we have no submissions to make.
All right. Well, let's hear from Mr. Perry then.
Well, may it please the court. My Lord, the position is that the only outstanding proceedings which might justify an anonymity order, and in answer to your Lordship's question, what power would be exercised, the most obvious power would be a Section 4, subsection 2 Contempt of Court Act order. The only case in which that arises is in the SF, PB, CS and KT application, because there are proceedings in relation to 3 of the applicants that have yet to be tried, as I understand it, and one of them there have been no proceedings at all as yet. But in relation to CP and CC, no need for anonymity. KSS, no need for anonymity. UB, no need for anonymity.
Right, thank you. But in the cases in which there are still proceedings to be tried, do all or any of them come into the category which might be described in very shorthand terms as cases in which either the EncroChat evidence is inadmissible and there is no case, or the EncroChat evidence is admissible and the whole case turns on the EncroChat evidence? In other words, are there cases in which the admissibility of EncroChat evidence will only be part of the evidence which may be available to the prosecution?
Well, Lord, I'd have to defer to Mr. Lacker, who has, I think, more information about the underlying proceedings in relation to those cases.
Yes. So, Lacker.
Lord, the 3 SF, PB and KT, as I understand it, do have outstanding proceedings. I don't represent them in the criminal proceedings.
No.
My understanding is that in respect of certainly SF and KT, that the evidence against them, if not entirely, it is principally the EncroChat evidence. And I know that in respect of both of those applicants, there have been at least attempts to obtain expert evidence in respect of admissibility of this evidence. As your Lordship knows, that particular train is still on the rails, not entirely off, but our concern would be that in those circumstances, not anonymizing their details may prejudice the criminal proceedings against them.
But I'm sorry to press on this point, but principle of open justice is very important.
Yes, of course.
What is the prejudice? Potential prejudice. I mean, very often, the sort of circumstance in which plainly there needs to be an order is if appellate proceedings exclusively focus on discussion of an applicant's previous convictions, for example, which may well be inadmissible in any criminal proceedings. But here, either the EncroChat evidence is in or it's out, and if it's out, there may be little or no prosecution case left. If it's in, then it's very difficult to see what prejudice there could be if some attentive juror scouring the law reports had come across something about this court hearing an appeal about admissibility.
Lord, it's in those cases where there may be some residual evidence, as I say.
Yes.
I'm not entirely familiar with the complete detail
No.
of those cases, that there is residual evidence. It's also the case that in those cases it wouldn't simply be jurors scouring the law reports. The reality is that this case has generated a lot of interest in the media.
Yes.
And inevitably it would be something that is likely to be reported in the much wider media.
Yes. All right. Well, shall we just proceed on an anonymised basis and decide this later? Yeah. All right. Well, thank you all. We'll, for pragmatic reasons at this stage, we'll proceed on the basis of the existing anonymisation, and when we give our decision, we'll address that issue as well as everything else. All right. Thank you. Yes, Mr. Ryder, back to you.
My Lord, I understand the court required an additional hard copy of the authorities bundle, which we have here.
Oh, that's very kind, thank you.
Does my Lord require me to go through representation?
It might be as well just to check we've got everybody on
Yes,
our
of
list,
course.
please. I don't want to miss anybody off if they're to be credited.
Mr. Palmer and Mr. Crump are represented by myself and Mr. Cashman.
Yes.
Mr. Shergill is represented by Mr. Schofield. Mr. Butt and Mr. Ahmed are represented by Mr. Choker Casey and Mr. Cook.
Yes.
SFPB, I think KT, but your other client can be, and Mr. Somerville are represented by Mr. Abbas Casey and Mr. Brewer. And the National Crime Agency are represented by Mr. Perry Casey, Mr. O'Brien Casey, Ms. Ailes and Mr. Deacon.
Right. Thank you.
This is an application for leave to appeal to the Court of Appeal from the decision of the IPT dated the 11th of May 2023. And I represent, as I've indicated, Mr. Palmer and Mr. Crump, and I intend to make submissions in relation to our 3 grounds of appeal. The first ground of appeal on which we seek permission is set out in, there's no need for you to turn it up unless you wish to, in our core bundle, tab 1, page 14, which is section 9 of the IPA. It's that issue, ground 1. And our ground of appeal is that the National Crime Agency breached section 9 of the Investigatory Powers Act because it did not have a targeted interception warrant. The IPT erred in concluding that the NCA's conduct for which they were seeking authorisation fell outside the scope of section 9, and it follows from that that the TEI warrant issued was unlawful and in breach of section 9. Our submissions on this point are set out in detail at core bundle, page 77, paragraph 28. Sorry, it's tab 2, page 77, paragraph 28. But in dealing with this ground, I'll be making 3 headings of submissions. First, I will explain why we say this situation fell plainly and clearly within section 9 of the Investigatory Powers Act. And that's on the basis of a simple and straightforward reading of the express provisions of the IPA. Secondly, I will set out how the IPT sought to disapply Section 9 to this situation, and why, in our submission, doing so was an error of law because it required them to misread the IPA in doing so. And thirdly, I will deal with the NCA's submission that leave should be refused on this point because it was included in the decision of ABDC by the Court of Appeal Criminal Division, and in their submission that would bind this court in considering this appeal of the ruling of the IPT on this point. On that final point, as you'll see as I develop it, our primary submission is that the circumstances in which the IPT had to consider the point are fundamentally different from which the Court of Appeal Criminal Division had to consider the point, but I'll explain that in more detail when I get to that point. So, under the first heading, why do we say that this situation fell plainly within Section 9 of the IPA? The context, as my lords know, my lord and my lady know, is that on the 1st of April 2020, interceptions began on the EncroChat platform. But prior to the interceptions starting, the NCA were faced with two requirements from the JIT and the French authorities. Those two requirements are mentioned in the warrant application. For the sake of reference, if it's needed, it's in the supplementary bundle, tab 3, pages 55 to 57. I'll come to that in more detail in a moment. But of the two requirements that the French needed before interceptions could start, the first was that the French, or the JIT, insisted on some UK lawful authority for the interception activity they would be doing of communications of people in the UK. And this is described, or the request from the requirement from the French is described in the warrant application as them being granted permission to do those interceptions. It's important to, for this point, to be conscious of the fact that that activity was the interception of communications of people believed to be located in the UK. And I emphasize that point because it's not what might be called a different type of foreign intercept point, where a country is being asked to intercept communications in their own borders at the request of another state. This is different. This is a request where the UK is asking another state to intercept the communications of people within the UK. And the French position, or the JIT position, was that if they did not have lawful authority or permission prior to the interception starting, they would not triage and make available the product for the UK authorities. And that is mentioned in the warrant supplementary bundle, tab 3, page 57. The second requirement, not particularly, or not as significant in relation to the Section 9 point, is that in addition to having that domestic authority separately, the French specifically wanted lawful authority in the form of an EIO for providing the UK with the product that it obtained from those interceptions of communications of people in the UK. So on that first point, the key question in our submission for the NCA was how could the NCA give the French the lawful authority, or the JIT, the lawful authority for that activity? In other words, having another state intercept communications taking place within the UK. How could they do that under domestic law? In our submission, that situation is explicitly provided for by the IPA. But in order to understand that, one is required to go through the IPA as it is constructed to see what warrant you need, and it will tell you which warrant you need for this situation. If you start the other way round with the warrant you want or the warrant you have and try to find a way to squeeze that warrant into Section 9, you will go awry and you start having to ignore or rewrite Section 9 in order to make that warrant fit. So the proper way to approach this, unsurprisingly you may think, is to look at the IPA, go through the sections, and it will tell you, in this situation, what type of warrant you need. So if we begin with the authorities bundle, for the Investigatory Powers Act, tab 2. And just if one looks at the heading of the Act, Part 1 Part 1 is headed General Privacy Protections. And those general privacy protections, sections 1 to 14, apply across the Act for any type of warrantry that you get. They are of fundamental importance to the Act. That's why we respectfully say they are framed as general privacy protections. So if you look at the general privacy protections, the first question may be, is what the French were doing an interception at all? And the answer to that is contained in the general privacy protections under the definition of interception under section 4, which is page 29 of the authorities bundle. Tab 2, page 29. Section 4.1 concerns and defines an interception in the course of its communication, and that in the course of its transmission, and that phrase is a term of art, perhaps different from some might understand the natural meaning, because it includes, in the course of its transmission, communications that are both being transmitted, for the purpose of today I'll call those live transmissions, being transmitted, and those which are being stored in or by the telecommunications system. So the definition of interception in the Act, and everywhere it appears in the Act, unless qualified, is expressed as including both live and stored communications.
So where do you get that in section 4?
4 is for the purpose of this Act in the course of its transmission by means of telecommunications system.
Yeah.
The person does a relevant act, and the effect of relevant act is to make the communication available at a relevant time. And if one goes down to 4.4, relevant time is any time while the communication is being
4B.
transmitted.
Yeah, thank you.
So it's 4A and 4B are included in the definition of interception. How does one get or give the lawful authority for an interception? That is also in the general privacy protections, and we get the answer to that from section 6, which is page 31. And section 6 tells you, and I won't read it all out, but you can see it in section 6, 1 and 3. And obviously, were we to be, if we're in a position to do so, I'm only able today to, for the purpose of this hearing, go through it in summary detail. But our position is, you can see in section 6 that you can get lawful authority from a targeted interception warrant, that's 6.1a. I'm going to call that a TI, for the purposes of today, TI warrant. And a TI warrant applies to interception. So that means a TI warrant covers both live and stored communications. A TI warrant covers both. Under section 6.1c, you can also get under part 5 a targeted equipment interference warrant, 6.1c1. A TEI warrant under Part 5. But that warrant, while it can be given for the interception of communications, only applies to the interception of stored communications. So TI applies to both, TEI applies only to stored. Therefore, these are not separate and distinct regimes when it comes to live and stored interception. They are overlapping regimes. A TI can do both, a TEI can only do one. Both warrants effectively create permission and a legal structure to authorize the activity in question and sets out the purposes for which that can be done. They make the authorized public authority responsible for doing the interception. It is their interception. But that authority can get assistance from a third party And that is set out in almost identical terms in section 15.5b. And just for reference purposes, that's page 38 in part 2. For a TI warrant, that is 15.5b. And for a TEI warrant, that is at page 94. Page 95. 99.5b. And I mention that because in due course, underground 2, 99.5b is important. But in almost identical terms, that the warrants allow permission to be given. So to give lawful authority for a TI or a TEI, the NCA is doing the interception, but it would be requesting or requiring the French to do it. So which warrant at this point should the NCA get? And let's proceed on the basis that it's a stored communication. Which warrant does they get? Well, whether it's a TI or a TEI doesn't indicate that, because either can apply to a stored communication. So something else within the Act may give an indication as to which it is. The mere fact that it's a stored communication doesn't tell you. And the answer in our submission is in section 9. Section 9 is contemplating exactly the kind of situation that was happening here. And if one looks at it, it's page 32, tab 2, page 32, restriction on requesting interception to overseas authorities. This section applies to a request for any authorities of a country or territory outside the United Kingdom to carry out the interception of a communication sent by or intended for an individual who the person making the request, in other words, the UK authority, believes will be in the British Islands at the time of their interception. A request for which this section applies may not be made by or on behalf of the person in the United Kingdom unless a TI warrant has been issued under Chapter 1, Part 2, or a targeted examination warrant, it's not relevant for our purposes, has been issued. So Section 9 tells you exactly which warrant of those which can authorise the interception of stored communications the NCA needs in exactly this situation. There is no qualification or carve-out for it being not applying to stored communications, and we know that because when Parliament chooses to do that, it explicitly carves out stored communications from the definition of interception. And one may need to look only at Section 10 to see that, where in Section 10, Parliament has applied to interception but carved out the provision for stored communications. That isn't the case in Section 9. There is no carve-out. So Section 9, read consistently with the definition and the rest of the Act, applies to both live and stored communications. So the answer to the NCA's question as to which warrant it should need, and to some extent to the Judicial Commissioner, which warrant is appropriate, is expressly provided for in Section 9. If anybody had put their mind to it, they would have seen that. And it applies even if it is a stored communication. In the choice between a TI and a TEI for intercepting stored communications in this situation, there is no choice because Section 9 indicates a TEI cannot be the appropriate warrant. It is a TI. The entire answer to the NCA's question, in fact, in our submission, the answer to the entire EncroChat case is in Section 9. And Section 9 is the answer to the warrant that should have been given. The IPT's response, my second heading under this ground, begins at paragraph 96 of the judgment, tab 8, at page 311. And in summary, the IPT adopted the reasons of the Court of Appeal Criminal Division in ABDC. In particular, the IPT held that the general privacy protection is designed to prevent the circumvention of the regulation of Part 2 activity. Now, that approach to Section 9, that it regulates Part 2 activity, doesn't explain to you which warrant you should get. Or more importantly, doesn't remove a TEI warrant, doesn't remove a stored communication from Section 9. if one starts with what kind of warrant do you need in this situation, it is a TI. And therefore, Section 9 is dealing with Part 2 activity because it is saying you need a Part 2 warrant in this situation. The error seems to be that the Court of Appeal Criminal Division and the IPT proceeded on the basis that Section 9 has no application for stored communications. It's not, the issue is not Part 2 activity. They seem to be disapplying it to stored communications. And there is simply no basis for that on a plain reading of the definition of interception and Section 9. Part of the problem in our submission is that the Court of Appeal Criminal Division and I'll come on to why that may have happened, but the IPT as well, may have been asking itself the wrong question and trying to understand what was needed by going backwards. In other words, starting with, if the NCA has a lawful TEI warrant, does Section 9 apply? But that's the wrong approach, because the proper way to analyse this is moving forward. In the Section 9 situation, what type of warrant do we need if it is a stored communication? In other words, which of the two stored communication warrants do we need? And when one approaches it that way, as in our submission one should have done, the answer is plain. The IPT seeks to draw support from its construction of removing stored communications from Section 9 by taking what it believes to be a purposive approach to construction. And I'll deal with this in summary. But in particular, the IPT indicated, it said that to interpret Section 9 as applying to stored communications, in other words, a TI would apply to stored communications in this very specific situation, would give a windfall benefit to defendants whose communications were intercepted because it would be under a TI in this specific situation. And the IPT's view was, we don't see why Parliament would have intended to give that windfall benefit. Our response to that position is as follows. Firstly, just as a matter of general principle, the decision to mandate a TI warrant in this situation and the consequences of doing so in criminal cases is a policy decision for Parliament. And Parliament may have all sorts of good reasons, including whatever information it's received in deciding how to frame the Act, for making that policy decision. So unless such a conclusion is not possible in the ordinary reading of the Act, it is, we say with great respect, the Court's function to give effect to the will of Parliament as expressed in the plain words of the statute, not to seek to find an interpretation that second guesses or disapplies the plain words. But secondly, we submit there are two perfectly understandable reasons why Parliament may have decided it was appropriate for a TI warrant, which applies, as I've said, to both live and stored communications, should be appropriate in this situation. Firstly, Section 9 relates to the specific situation of asking a foreign state to intercept communications of people in the British Islands and to try and put that on an equivalent footing with if the public authority in this country was doing the interception themselves. And Parliament may well have not wanted to create a loophole that might have been caused by the fact that foreign states do not make the same rigorous distinction between live and stored communications that this state does. Nor are they always willing, as we know painfully well from this case, to disclose the methodology of how they do an interception. So it may not be possible, and Parliament may well have anticipated it may not be possible to have any reliable information as to whether a communication is being intercepted when it's live and stored if a foreign state is doing it. So Parliament, it seems, has proceeded on the basis that the warrant that can apply to both live and stored is the appropriate warrant in this situation of uncertainty, not a TEI warrant. And whether one agrees with that or not, it is, in our submission, an understandable reason why Parliament may have decided this is the appropriate warrant for this case. There is a second reason why we say that Parliament might have wanted to do this. A TI warrant, it's required under Section 9, a TI warrant granted to law enforcement, such as the NCA, requires the personal authorization of the Secretary of State. Whereas a TEI warrant granted to law enforcement does not. Parliament may well have taken the view that that additional and important protection and the personal involvement of the Secretary of State is needed in a Section 9 situation where an interception is being requested to be undertaken by a foreign state on UK soil or on people who are in the UK. Now, one may agree or disagree with those policy considerations, but we say it is perfectly understandable why Parliament may have decided to frame Section 9 that way and only require a TI warrant, not a TI warrant. But in any event, the Wimphal argument is not a proper tool for construction, particularly when it involves disapplying something as fundamental as the Section 9 general privacy protections in their application to stored communications. The third point on this is why the Court of Appeal decision in ABDC in our submission is not binding on this court and why it is not a reason to refuse permission at this stage. We've addressed that in some detail in our skeleton submissions, Core Bundle Tab 2, Section E, page 76, paragraphs 26 to 27.3. So I adopt those submissions, but I make three, I'll summarise in three reasons why we say that decision should not be a bar to giving leave to appeal at this stage. The Court of Appeal Criminal Division and the IPT, whose decision you are considering for the point of appeal, decided the matter in relation to Section 9 in very different contexts. First of all, the Court of Appeal's Criminal Division's focus was almost entirely on what constitutes an interception under Section 4. And they make this clear in a number of ways. First of all, in paragraph, it's authority, you don't need to put it up, it's authorities bundle, tab 11. And they make it clear, the Court of Appeal Criminal Division, at paragraph 51, that's authorities bundle, page 389, they call it the critical issue. At paragraph 79, it's called the only substantial question. And I don't think you have this document, so we can make it available to you, but it is made clear in their refusal to certify a point of law of public importance. I don't think you have that in your authorities bundle, and so we will make sure you have a copy of that. But they describe that, and I'll read from it now, but obviously I'll make sure there are copies, as the decisive question, and they describe the other issues as being not essential to the decision in this case. I had thought that was included. It's not, so I'll make sure that my learned friends, if they don't have it, and my lords and lady have it.
Can I just, sorry to interrupt.
Yes.
You keep on referring to ABDC.
Yes.
By the time it's got into the law report, it's RNA 2021 Queen's Bench, is that right? Because I just don't want any confusion between that.
Yes. The RNA is also, I'm not sure if Atkinson is RNA in the law report.
We'll just look at the law report and just make sure that you think. My understanding is that it's.
You may well be right,
but well, you're the
yes,
advocate.
you are absolutely right. You are absolutely right.
Well, if we just call it RNA, it's going to be easier because then we know we're talking about the 2021 QB. Thank you very much. Sorry to interrupt.
No, I'm grateful for that. It's the one under tab 11.
Yeah.
Secondly, the criminal court was in a wholly different position, and it may be argued a somewhat artificial decision to be considering Section 9, and this applies also, as you go to Section 10. When dealing with Section 9 and Section 10, a criminal court had to proceed on the basis that the TEI was lawfully issued. Now, it's a matter of trite law, but one cannot in a criminal court submit that a warrant was issued unlawfully unless one challenges that warrant and has it set aside in the administrative court.
And even if you do, the state can go under Section 59 of the Criminal Justice and Police Act and apply for leave to use the information.
Yes.
Yeah.
But the point here is that the criminal court had to proceed in A on the basis that the TEI warrant was lawfully issued.
They seem to have entertained argument about whether it was lawfully issued.
Well, we would say that is...
Perhaps they shouldn't have done.
In our submission, we don't think that, we respectfully think they did take that approach. We certainly couldn't submit that it was unlawfully issued. And we say their approach is revealed in paragraph 76. Can I take you to that?
Of course.
It's at page 395, tab 11 of the authorities bundle, when dealing with section 9. Ground 4 relies on the prohibition in section 9 of the 2016 Act against requesting interception without a part 2 target interception warrant. There was no warrant of this kind, and unlike section 10, section 9 contains no provision dealing with the communications which are stored in or by the system. The defendants therefore contend that activity was rendered lawful by the clear terms of section 1C and 10.2, and the act was rendered unlawful by section 9, which does not refer to stored communications at all. That would be an extraordinary outcome. In other words, the court is approaching it on the basis that this is a lawful TEI warrant, because it's lawfully issued in accordance with section 6.1c, which is part 5 warrant, TEI warrant. But our submission is characterised as saying it is lawfully issued under that, but then once it's lawfully issued, we are then trying to say it's unlawful under section 9, or section 9 applies to that warrant. Can I put it another way? The position the Court of Appeal is in, criminal division, is having to say if the TEI was lawfully issued, does section 9 apply to it? And their answer is no. But that is not the proper question for the IPT. The IPT starts forward rather than backwards. The IPT says, what is the right, or should have said rather, what is the right warrant for this situation? What does section 9 tell us? So to put it in simple terms, the Court of Appeal Criminal Division is having to work out how does section 9 apply to a lawfully issued TEI warrant, whereas the IPT should have approached on the basis, what is the appropriate warrant in a section 9 situation? Those are two fundamentally different questions. And as a result, it is not surprising that in our submission, there is a slightly tortuous attempt to work out whether section 9 applies to a TEI warrant, whereas that really isn't the question. The question is what sort of warrant should apply in a section 9 situation. It's a different question. There is also a reference in the case of Atkinson to, I don't have it immediately to hand, but I can ensure that you're given it to the court in Atkinson approaching it in that way. But we're dealing with A, and so I keep my submissions in relation to A. But that is the situation that the Court of Appeal Criminal Division was in our submission. The IPT, as we submit, were in a different position. And if we are right about that the IPT isn't bound by the lawfulness of the warrant and trying to fit the TEI into section 9, but is approaching it the other way around, that explains the flaw in reasoning by the Court of Appeal Criminal Division, because they are saying section 9 doesn't apply to a TEI warrant. That might be right, that's not the question. The question is, can you get a TEI warrant in a section 9 situation? And if we're right about that, then the two courts were considering different questions, and the IPT should have recognised that. Our second point, I've got to be careful of time, our second point is that the IPT did not consider itself bound by the Court of Appeal judgment. And so the IPT itself didn't consider it was bound by A. And we see that at paragraph 27.1 of our skeleton, and it's at paragraph 93 of the judgment. Our third point is that the respondents rely on the case of Young, the familiar case of Young, that indicates that a Court of Appeal decision is binding on the Court of Appeal and other divisions of the Court of Appeal. But of course, there is a well-known residual discretion for the court to consider matters that fall outside the categories of Young if there is a risk of significant injustice in a criminal case, and that's a Court of Appeal Criminal Division exception. But we would say, by analogy, it has application here when the court is considering the lawfulness of evidence that has fundamental effects on the trial or the fair trial of those who are before the criminal courts. And so there is a residual discretion in our submission, and this court is not tightly bound by the categories in Young. But even if this is a matter for dispute and for submissions, in our submission, if this court is to decide whether it should depart and is able to depart from the decision in A, that is a matter to consider once the full context, and I've only been able to touch on it, of the decision in A is considered by you, and you compare that to the considerations and position the Court of Appeal was in. It is not a reason in our submission for not granting leave at this stage. I think I have about 10 to 15 more minutes, but I've finished that first ground.
Right. Well, just before we move on, there are a couple of things I'd like to ask, please. I think you said a moment ago, but I just want to make sure I've been accurate in my note. I think you accepted a moment ago that the CACD may well be right when they said that Section 9 does not apply to a TEI warrant. You went on to say, but they were asking themselves the wrong question. Have I correctly noted that?
Well, I put it in more qualified terms, and it may be in the way I phrased it, I should have been more qualified. But I think it was a conditional submission. So if they were right, even if they were right about that.
Right.
Because the important question is, we say you cannot have a TEI warrant in this situation. You should not have one. And so the reason Section 9 doesn't apply shouldn't apply for a TEI warrant is because you can't have a TEI warrant in this situation.
Well, I understand that. Which is why all right. The second thing was this. I just want to understand what you're saying about the Young principle. Can you just take me, please, to the authority which you say gives the court a discretion simply to depart on an ad hoc basis from the approach laid down in that long-established decision?
Forgive me, my lord, it's my fault. I wasn't saying on an ad hoc basis. It is a residual discretion which must be exercised only in exceptional cases when there may be a real injustice to the liberty.
What's the authority for that?
So we would rely on, and they're not in the bundle, but we would rely on the case of Gould, case of Taylor, and there's a more recent case in which the propositions are summarised, I think, by Lord Justice Bean in the case of Hayes, which is the libel case, and he summarises those principles from Young. And as I said, it is a criminal Court of Appeal residual discretion, but we say it should apply by analogy when this court is considering an appeal from the IPT on what is essentially the admissibility of evidence in a criminal case, or the lawful, so forgive me, the lawfulness that may affect the admissibility of evidence in a criminal case. Forgive me.
Thank you.
We can, if it's helpful, provide the case of Hayes.
No, got the point.
In due course. Ground 2 is the lawful purpose of the warrant, and it was expressly set out in ground 3 of our submissions. In refusing Lee, the IPT did not set out the reasons for refusing this ground or finding against us on this ground in its judgment, but their position is expressed in their reasons for refusing permission to appeal to this court, and that's at Core Bundle tab 3, page 137, paragraph 7, which is in the NCA's response. They quote that particular part of the refusal. And the refusal included the framing, the tribunal found that the purpose of the warrant was to render the conduct of the JIT unlawful when otherwise it might have been an offence under the Computer Misuse Act, which the NCA might commit as a secondary party by encouraging it. Paragraph 78 of judgment, this is not an improper purpose. So I will, in headline form, I'll set out our submissions on ground 2. Firstly, a TEI warrant can only be issued for one of the statutory purposes in section 99. And in this case, the statutory purpose was to authorise conduct that was set out in the warrant. And we can see that in the supplementary bundle. I would ask you to turn it up. Tab 3, page 49. Under conduct description, the NCA, about 4 lines down, the NCA is seeking a TEI warrant pursuant to section 99(1)A of the IPA to authorise the interference with UK EncroChat handsets in accordance with section 99(2) of the Act and secure the obtaining of the communications and equipment data in accordance with 99(3). Due to the interference being conducted by the JIT, the NCA is seeking authorisation pursuant to section 99(5)B of the IPA. This would allow the NCA to require the JIT to provide assistance by conducting interference on the UK EncroChat handsets. Requiring the assistance to be provided by the JIT is what is sought to be authorised in order for the JIT to be acting lawfully. And that is, on the face of it, may have been, and there is a reason why I qualify that, thought to have been an appropriate purpose under section 99 for a warrant to be authorised. But what is clear is that that is what the warrant appeared to be authorising. We know, however, from the judgment of the IPT that tab 8 of the authorities of the core bundle, page 314, paragraph 108, that after some discussion about section 99, the IPT concluded that section 1995B has no application to this situation. In other words, when the NCA is seeking to require a foreign agency to carry out interceptions. We say that ruling puts the respondent in 2 situations which are irreconcilable. The first is our primary submission under ground 1. If the NCA was requiring the JIT to carry out the interceptions, then as I've already set out, that was a section 9 situation. The TEI warrant couldn't have applied and couldn't be granted lawfully in that situation. But secondly, if we're wrong about that, the IPT has nonetheless held, under paragraph 108, that the TEI warrant could not authorise the NCA to require the JIT to carry out the interception under the power pursuant to section 99(5)B. In fact, the IPT has concluded that, as a matter of law, it couldn't do so. So the IPT, by saying it has no application in this situation, is nevertheless saying that the purpose of the warrant was to render the conduct of the JIT lawful, when otherwise it might have been an offence under the Computer Misuse Act, which the NCA might commit as a secondary party by encouraging it. Simply trying to render something lawful is not of itself a purpose for which a warrant can be granted, because the warrant is granted to authorise conduct, not simply to provide a legal cover for no specified conduct. The IPT, in our respectful submission, has confused the purpose with the effect of the warrant. The purpose must be for a lawful purpose, to authorise conduct that's carried out under the warrant. The effect of authorising that purpose may be to make particular conduct that's authorised lawful. But that only connects to something if it is for the purpose of authorising that conduct, not merely to create the intended effect of the warrant. The TEI warrant could not be merely for the purpose of giving legal cover to something that could not be done or is not specified in the warrant, because the conduct that was specified on the IPT's finding could not be a purpose for which the warrant was authorised. So by finding 99(5)(b to be a purpose that is not, cannot be the reason for a warrant to be granted in relation to a foreign agency, the IPT has simply described the effect, the intended effect of what the warrant was as the purpose, while taking away the conduct that needed to be authorised in order to give effect to that intention. In our submission, it's another error that is caused by having to start with the TEI and work through how you get the result you want by starting there. And the answers, unfortunately, cannot fit, which create this, we say with great respect, confusion over the way Section 99(5)(b applies. And as your lordships will be aware, the finding of the IPT was not a submission any of the parties made and expressly contradicts the submission of, for example, Mr. Justice Dove made below. For reasons I will come to the end, this has ramifications not just for 99(5)(b, but for 15(5)(b) as well, because they're in identical terms. Ground 3. The NCA, in conjunction with the DPP, breached Section 10 because it did not have a mutual assistance warrant. And in our submission, the IPT erred in concluding that it had no jurisdiction to consider the complaint under Section 10, and relatedly in concluding it had that no mutual assistance warrant was required. I think I can deal with this point fairly quickly, particularly given the time constraints. Firstly, in relation to jurisdiction, I think there is no dispute, sorry, forgive me, I should start over. In relation to this point, our submissions are at Core Bundle Tab 2, page 85, paragraphs 52 to 55. And there we set out that there is, the jurisdiction encompasses proceedings related to the taking place of conduct falling within Section 65(5) that takes place in any challengeable circumstances, which are then defined. We go through the various conduct that could be, which could be applicable in this case, and the challengeable circumstances. I think suffice it to say, the position for the purpose of this appeal are essentially this. The IPT agreed with the applicants and not the respondent in finding that conduct within Section CZM was applicable in this case, but found there were no challengeable circumstances. And one of the reasons they found there were no challengeable circumstances was because they disagreed with the merits of the argument that a mutual assistance warrant was required. So for the purposes of jurisdiction, there is a fairly simple point. If we're right on the merits of that point, then there can't really be any dispute that there is jurisdiction on the IPT's finding. If we're wrong on the merits, then the IPT would say, and did say, there is no jurisdiction. But we have set out an alternative route to jurisdiction, which we say is at Core Bundle, we have set out in our skeleton at Core Bundle Tab 2, page 90, paragraph 69 to 72. On the merits of why a mutual assistance warrant was required to comply with Section 10, I don't have time to be able to go through in detail those points now, and I wouldn't wish the fact that I'm unable to do so to be any suggestion that this is a point that we are placing less weight on than other points. It is nevertheless as an important point for us. But they are set out in detail in our submissions, in our skeleton at Core Bundle Tab 2, at page 87, at paragraph 56 to 68. But in summary, the position is that we say the statutory power that falls within the exception to requiring a mutual assistance warrant, the IPT found was the EIO itself. And in our submission, you'll see in our written submission, that is a circular approach to that provision, because it means once one has an EIO, there is no need for a further exception, because the EIO is itself a statutory power, which provides the exception to needing a mutual assistance for that EIO. And in our submission, that can't be right, and it isn't right. We say when one looks at the regulations that were intended that were in the directive and were intended to be set out or reflected in Section 10. The reality is that the statutory power isn't the EIO itself. It's an analogous statutory power to an equivalent domestic statutory power. In relation to whether the decision in A should result in appeal being refused on this point, we make the same points we make in relation to section 9, our ground 1, including that this was not an essential part of the decision in A, and the IPT itself did not consider itself bound by A on that point. It would be, in our submission, somewhat perverse if the IPT didn't consider itself bound in that way, but this court considered it to be a ground on which not even leave to appeal would be granted. And I would add, just as an aside, that there was very little argument on this point before their lordships in the Court of Appeal Criminal Division, and neither party was making the submission that has been reflected in that decision. It wasn't a submission that was being made by the... It was a fallback position that was set in Mr. Justice Dove's judgment, but his primary position on Section 10 is it didn't apply at all. The Court of Appeal Criminal Division were with the defendants on that point. It says Section 10 did apply, but adopted Mr. Justice Dove's fallback position. But it wasn't a subject of any detailed argument, and it wasn't a submission that the Crown was making in that case. They relied on the primary position on Section 10. For those reasons, we submit it's appropriate to allow this point to be properly argued. Can I just finish very briefly with important and compelling conditions? Important and compelling reasons to grant permission. These are set out in our skeleton at Core Bundle, tab 2, page 91, paragraph 73 to 78. We submit that if this court thinks there is or may have been an error of law in a judgment of the IPT about the interpretation of primary legislation, the IPA, and how it should be read and applied by the NCA, IPCO, and others, in the case of Section 9, which is in the General Privacy Protections, Section 99 and Section 10 of the IPA, the court should be slow to refuse permission on the basis that such errors or potential errors in the interpretation of primary legislation of general applicability are not sufficiently important and compelling. It is important to keep in mind that this concerns the interpretation of the general privacy provisions and warrantry that can be used to request assistance from foreign agencies. Such matters, and I respectfully say, making sure such matters have been properly decided, are of high importance. The potential consequences of an erroneous legal approach to primary legislation of this kind, particularly in the context of surveillance law, are of themselves compelling and important. To say otherwise risks doing an injustice to the importance that should be placed on primary legislation, and on which the rule of law depends, and the correct legal approach in this situation is often in secret. So having an opportunity to clarify the correct legal approach in this court would be of enormous benefit to those who are trying to work with this decision. In any event, we say the grounds of appeal on which we seek permission are important and compelling. They are important and compelling not just for these applicants, but for other connected EncroChat cases, and more broadly for interception cases generally, and for confidence and clarity within the legal framework of interceptions and surveillance. They're also important because the rulings related to new provisions on major operations will affect training, practice, potentially for years to come, that often takes place behind closed doors. And if the current rulings are or may be wrong, this is an opportunity to correct them. If they are not, then the Court of Appeal can make that clear after hearing detailed argument, not on, for example, Section 9 and 10, a decision of the Court of Appeal which was primarily about a different point. And therefore, there can be clarity about this issue and those provisions. In relation to Ground 1, Section 9, we say the reason it is compelling, important, and has such significant effect is that that decision effectively removes the general privacy protections of Section 9 from stored communication interceptions. And it means that a domestic agency can make a request under Section 9 for domestic warrantry in such a situation with no domestic warrantry in place. In other words, a TI for stored communications on this ruling is not required by Section 9, and a TEI under Section 99(5)(b) has no application in this situation. We submit this would be a remarkable development it means that a type of interception falling within the definition of interception and apparently included within the privacy protections has been removed from those protections entirely. In relation to ground 2, we say that this point was, first of all, we say this point has not been considered by the Court of Appeal Criminal Division. And it means that the purpose of a warrant need not be to authorise conduct in accordance with what is in the warrant, but it can simply be to provide legal cover in a way that doesn't authorise any specific conduct. And in our submission, that is not right. The conduct authorised in the warrant depends on 99(5)(b) being applicable in that situation, which the IPT has expressly said it isn't. In particular, it affects section 15(5)(b) TI warrants as well. And can I just indicate why we say that and why it causes a problem for other provisions of the Act? If the IPT is right that 99(5)(b) does not apply in requiring foreign agency to do an interception of communications, then how would it apply? What would be said in the TI warrant if there is what is agreed to be a Section 9 situation? In other words, we see in Section 9 a TI warrant is needed in some situations. What would be in that TI warrant? If 15(5)(b) is interpreted the same way as 99(5)(b), it cannot require a foreign agency to carry out the interception. Therefore, how would you have a TI warrant under Section 9, which is mandated by the Act, when you can't use 15(5)(b) to be able to do that, because the paragraph 108 of the IPT judgment said it's not applicable in that situation? What would be the provision? How would a TI warrant be used? In our respectful submission, this is a confusion about how that section should be interpreted and how there may be unforeseen consequences of the way the IPT has expressed that part of the ruling that needs to be sorted out. And it causes further confusion because if it's not on ground 2, if it wasn't pursuant to section 99(5)(b), was it then in accordance with the warrant? And if it wasn't within accordance with the warrant, in other words, if what was received wasn't in accordance with what is in the conduct description of the warrant because it couldn't be authorised, how would it fall within the exception to section 56 of admissibility, which requires it's done in accordance with a lawfully issued TEI warrant? So for those reasons, again, the unforeseen consequences of that particular part of the IPT's ruling under paragraph 108 needs to be, we say, considered and clarified. Finally, in relation to ground 3, we say that circular interpretation of statutory power renders nugatory the protection that Parliament intended to provide by simply making an EIO fall within its own exception of a statutory power. We've set out the reasons in detail for that in our submissions, and I don't have time, unfortunately, to take you through those arguments. But those are, in our submission, substantial arguments, which we say, with respect, merit a hearing. We do understand that the respondents are likely to say, you had an opportunity to argue this in the Crown Court, you had an opportunity to argue this at the Court of Appeal Criminal Division, you've argued it in the IPT, you shouldn't now be allowed to argue it again here. We understand that point will be made against us. But we ask you to bear in mind that, and put yourselves in our position when this litigation began, we had to make a decision whether we started in the Crown Court on these points or started in the IPT in making these challenges. And we couldn't challenge the lawfulness of the warrant in the Crown Court. We knew if we were ever going to have to do that, we would have to go to the IPT. And that is precisely because the IPT must take a different approach to the lawfulness of the warrant than the criminal court. The authority of GS, which supports that interpretation, was one which we were dealing with in the Crown Court when trying to make arguments around the fact that the Crown Court judge could not question the lawfulness of the warrant. Once the criminal court determination was made, we go to the IPT to have what we submit is an opportunity to take the right approach to this issue, which is not saying does a TEI warrant fit this situation, but say what is the appropriate warrantry for a stored communication? Is it TI or TEI? And the answer, for the reasons I've set out, is TI. For those reasons, we respectfully submit we are not simply seeking to prolong arguments that have been made against us. We are trying to ensure that we are in the right forum for those arguments to be properly clarified. I know I've gone slightly over, and I apologise for that. I'm hoping that my own friends can.
Can I just ask two questions?
Yes, of course.
Sorry. So you're saying that 99(1)(a), which is what they applied for, doesn't apply because Section 9 should have applied. Is that your effective submission on ground one?
Section.
Because I mean, the warrant they applied for was a 99(1)(a)
Yes.
TEI.
Yes.
And you were saying that was wrong because they should have gone Section 9. Is that effectively your
Yes.
first ground?
In a Section 9 situation, you cannot authorise the interceptions using a TEI.
That's fine. I just wanted confirmation of that. And on 99(5), you say, well, it doesn't come within 99(5)(b). But how do you deal with the fact that 99(5), a targeted equipment interference warrant, which you say shouldn't have been applied for, also authorises the following conduct, brackets, in addition to the conduct described in the warrant? So it's in addition to the conduct described in the warrant, and you're saying in your ground 2 that, well, the error is there's no conduct there.
No, it may be my fault for not expressing it, and forgive me.
No, I'm just trying to clarify
Yes,
the point.
yes.
Yeah.
99(5)(b) is, our point is that the IPT says that provision, which is that the conduct, that it authorises conduct by any person in pursuance of a requirement imposed by or on behalf, which is the basis on which 99(5) TEI warrants and TEI warrants would seek foreign assistance. See the judgment of Mr. Justice Dove. The IPT has said that has no application. That wasn't our submission, that's the IPT's position. And so by saying that provision in which assistance is required, which enables assistance to be given, has no application, the IPT ruling has effectively disabled these warrants, both under 99(5) and by implication 15(5)(b), from being able to to require the assistance of a foreign agency, because it is expressly said in Section 108 it doesn't apply in this situation.
Well, so that's your reading of paragraph 108?
Yes.
Right, okay, thank you.
Yes.
Lords, my lady, the time I have is even shorter than I had anticipated, so I'll try and keep it focused. The focus of our submissions turn on the precise terms of Section 101(1)(c) of the IPA, which requires that the warrant relates to equipment belonging to, used by, or in the possession of more than one person or organisation, where the interference is for the purpose of a single investigation or operation. The tribunal held at paragraph 133 of their judgment, which appears in the core bundle at pages 319 and 320, that the characterization of the investigation for the purposes of the warrant is one relating to the criminal use of technology did not...
So which paragraph of the judgment?
It's 133.
133.
And it's core bundle at page 319.
Yes, thank you.
They held that the characterization of the investigation for the purpose of the warrant as one relating to the criminal use of technology did not involve an error of law. It's our submission that that ruling was wrong. The reading of Section 101(1)(c), that the criminal use of technology satisfies the requirement for a defined subject, in our respectful submission, drives the coach and horses through the statutory provisions and renders the bulk regime entirely redundant. It would mean that any messaging platform, such as WhatsApp or Signal, could be the subject of a wholesale thematic equipment interference warrant. That could never have been and was not the intention of Parliament, as is apparent from a careful reading of the provisions. And no doubt the respondent's reply to that will be that such a widely drafted warrant, that is to say the criminal use of technology for WhatsApp or Signal, would necessarily fail the test of foreseeability of the extent of collateral intrusion. But in reality, that concern could easily be addressed by a sifting exercise that might be put in place using, for instance, AI. It is, in any event, we respectfully submit, a second-order question and denudes the statutory provisions, the statutory intent behind the list of approved subjects set out in section 101(1). In short, there would be no need for that sort of a list if the criminal use of technology was sufficient. That's all that section 101 needed to say. It is our submission that that ruling at paragraph 133 is inconsistent with the clear meaning of the statutory language, the clear intent of the statutory provisions, and the clear overarching purpose of the statutory scheme. Our three grounds of appeal are set out in our document, which is a core bundle of pages 121 going into page 122. And we submit there are three distinct grounds, albeit closely related, page 121, 122, the core bundle. Each of which raises important points of principle or practice, and there are compelling reasons for granting leave to appeal, both with respect to Operation Venetic and, more significantly, the wider approach to the IPA statutory scheme. Milan for Mr. Choker, King's Counsel, will be addressing the third ground set out in that document. Can I deal with the first two? Firstly, the interception was not on its face for the purpose of a single operation. It's always been conceded on behalf of the applicants that the thematic form of targeted warrantry allows for widely defined groups to be the subject of warrants. And it's not suggested that the subjects need necessarily to share a common purpose or be engaged in a common activity. Nor was it a requirement that all of the subjects of the warrants be named or otherwise individually identified. However, the clear legislative purpose of the scheme is nevertheless that the subject of the thematic warrant must be appropriately identified as set out in that list at section 101. And it was 101C which the NCA selected as the basis of its application for these warrants. And that requires that the interference is for the purpose of a single investigation or operation. And before I turn briefly to consider the nature of Operation Venetic, it is important, we respectfully submit, to consider the meaning in section 101(1)(c) of the use of the words single investigation or operation. Firstly, we submit the natural meaning of the statutory terms operation and investigation are clear. A genuine single operation or investigation must have a specific criminal target with a theme, common theme, which is independent of the fact that they've been deemed the subject of an investigation. It's difficult to improve on Lord Anderson's analysis in his first opinion at paragraph 26, where he said the first objection would be that the NCA's characterization involves a simple category error. A thematic warrant requires a theme more cohesive and more specific than simply wishing to break into an encrypted platform. By defining the relevant investigation or operation in terms of the penetration of a platform or network used by a vast and miscellaneous group of unrelated criminals, the NCA is neglecting the requirement of a target and stretching unduly the normal law enforcement and statutory meaning of the terms investigation and operation.
It's or operation. And I think
Yes.
what's said against you is the point that actually it is a single operation. You put on the bolt, which enables you to download the data.
Well, how?
And then that's what the answer is. What do you say to that point that the respondent makes?
We respectfully submit that simply the criminal use of technology cannot be an operation which falls correctly within the meaning of Section 101(1)(c). If that were the case, there would be no need for any other provision.
No, it's not the criminal use of the operation.
Yes.
The operation is what the law enforcement agency is proposing to do, put a bolt on. So which is for the interference is for the purpose of a single investigation. You say there are lots of investigations.
Yes.
Or operation, and single operation would be putting the bolt on. And what's the answer to that point?
The answer to that is that there would then be no need at all for the bulk regime. If that were sufficient by itself, there would be no need for the bulk regime at all, because every single application for a warrant would be described as a single operation.
Thank you.
It simply renders, as I say, that what was described in the authorities as a carefully drawn up suite of protections within the statutory scheme would no longer be the case, and that comes to our second ground of appeal. He went on to say it deploys a drift net rather than a clutch of harpoons seeking to set aside the statutory requirement of an identified and circumscribed criminal enterprise in favour of a wholly general attempt to uncover serious criminality of all kinds. We also respectfully submit the criminal use of technology is not on any natural use of the term a single investigation or operation. And as such, the tribunal has fallen foul of the simple category error identified by Lord Anderson. Secondly, submitted that this analysis is reinforced by the statutory supporting materials. The explanatory materials for the IPA, paragraph 298, which appears in the authorities bundle at page 647, reads as follows. A targeted equipment interference warrant may relate to equipment where there is a common link between multiple people, locations, or organization, where the interference is for the purpose of the same investigation or operation. So, for example, computers believed to be being used by terrorist group Group X, or equipment that is being used for a particular activity. Similarly, the equipment interference code gives a number of examples of the appropriate subject matters for thematic warrants, and they appear at paragraphs 5.10, 5.16, 5.30, and 5.33 in the authorities bundle at page 651 onwards. And each of the 5 examples have a cohesive subject matter, which is the subject of the single investigation, which go beyond the incidental use of a particular communication platform. It's our respectful submission that the clear legislative intent behind this provision is that the single investigation or operation must relate to targets with a common link, which goes beyond the mere fact that they are suspected criminals or are the subjects of the investigation or use a common technology incidental to their suspected criminality. Thirdly, it submitted that the interpretation we urge on the court is supported by the overarching statutory scheme. If the tribunal's ruling stands, any investigation termed the criminal use of technology by the criminal fraternity can be used as a vehicle by which any bulk data set can be deemed the appropriate subject matter of the thematic warrant, solely by nominally badging it so. And then the only safeguard would be the second order question, which is the foreseeability of the extent of the intrusion, which Parliament clearly considered to be insufficient by itself when it implemented Section 101. And as I've said, the Tribunal's ruling renders the bulk regime and its higher safeguard entirely meaningless. Even if Operation Venetic was a genuine single operation for the purposes of these provisions, the interception was not for the purpose of a single operation. So the purpose was not for the single operation. The primary, if not the sole purpose of Operation Venetic was to receive, triage, and disseminate the Operation Emma material on behalf of the UK to multiple existing and fresh investigations and operations, both known and unknown. So the dissemination of material derived from the interception was not incidental to or an anticipated additional benefit. It was the very purpose of the operation right from the outset. It's in those circumstances that we submit it cannot be said that the TEI related to equipment where the interference is for the purpose of a single investigation or operation. To be clear, we're not suggesting that a warrant cannot be issued to a single investigation or operation simply because it is anticipated or likely that the material derived following that warrant will be of use to or provided to another investigation. In those cases, such incidental secondary use of the intercepted material would not stop the interference being for the purpose of a single investigation or operation. But that was not the case here. The fact that the purpose of the interference was much wider than a single operation is plain, firstly, from the circumstances in which Operation Venetic was created. Secondly, the face of the EIO and the TEI warrant applications. And thirdly, the actual operation of Operation Venetic as revealed by the NCA's own briefing documents. Although there had been a previous investigation into the EncroChat platform itself called Project Venetic, this operation was wholly different. This version of Operation Venetic was expressly set up solely because the JIT had required a single point of contact in the UK. In truth, this was not a freestanding investigation into the operation of the EncroChat platform, those who set it up and those who sold the EncroChat handsets. That was not the purpose of this operation. It was, right from the outset, intended to be a clearinghouse for the Operation Emma intercepts. It's also clear from the warrant applications that the interference was not for the purpose of a single operation or investigation. The TEI application itself declared the NCA's intention is to use the data identified as being associated to criminals based in the UK and their organised crime groups obtained by the JIT to facilitate current UK law enforcement activity and future criminal investigations.
Sorry, where does that come from? Where are you reading
That
from?
was from the TEI application itself.
But where do we see it? You're obviously reading from something. It's just a bit difficult to follow.
Page 530, around there.
If it's not in the core bundle, we will provide it, but can I give the reference to that in a moment? No, those,
Is it part of the application for the targeted?
it is.
Well, that's from page 529 on
Sorry, what?
of the supplementary bundle. So is it page 537, page 10 of the document? Second paragraph, is that what you were reading? The NCA's intention is to use.
It is precisely that.
Right, thank you very much.
Thank you.
Thank you.
There is, in near identical terms, in the EIO application, and again I'll get at the reference for that in a moment, the NCA's intention, drafted by the request drafted to the CPS, the NCA's intention is to use the data identified as being associated to criminals based in the UK and their organised crime groups obtained by the JIT to facilitate current UK law enforcement activity and future criminal investigations. These will be matters, and so it goes on. And the EIO itself, again, in near identical terms. And so it was clear from the warrant applications that this was not for the purpose of a single investigation. Third, the true purpose of the interception is plain, we submit, from the actual conduct of the operation. Its sole interaction with that intercept material, that is to say the operation team's sole interaction with the intercept material, was to triage it on a daily basis. The NCA would immediately identify material either geolocated in Scotland or from already identified handles and immediately send it to the relevant law enforcement agency with no further development being undertaken, as was described. All of the other material was retained, but only insofar as it was necessary to identify an appropriate customer to receive the material. And once that had been done, it was immediately sent to them, again, with no further development. It's our submission that there is no reasonable description of this activity we suggest other than the purpose of the interference was for more than a single operation or investigation. The second ground, the tribunal's ruling unlawfully blurs the distinction between bulk and thematic warrants in a way which breaches the applicant's Article 8 rights. And contrary to the tribunal's ruling in refusing leave, it is submitted that this is a distinct ground. If the tribunal's interpretation of Section 101(1)(c), single investigation, is correct, then the lack of a clear distinction between the bulk and thematic regimes created by this ruling would render the entire statutory scheme in breach of the applicant's Article 8 rights, because the distinction between the bulk and targeted regimes becomes so indistinct as to be arbitrary, and any interference with the citizen's rights would therefore not be in accordance with the law. The Divisional Court in Liberty and the Secretary of State for the Home Department recognized that the lack of a clear statutory boundary between bulk and themed warrants potentially posed a risk of rendering the entire statutory scheme arbitrary. The reason why the court was able in that case to hold the scheme to be Article 8 compliant was the interlocking suite of safeguards contained in the statutory scheme, and in particular the careful oversight of the judicial commissioners and the tribunal of the bulk thematic boundary to ensure that its use was not arbitrary. And that's in the authorities bundle, paragraphs 176 to 178 at page 277. It is submitted that in taking the approach that it has, the tribunal has failed to provide a sufficient safeguard against arbitrary use of these provisions. We submit both of these grounds raise important points of principle or practice, and there are compelling reasons for granting leave to appeal, both with respect to Operation Venetic and the wider approach to the IPA statutory scheme. Can I then leave ground 3 to learn from Mr. Choker?
Yes, thank you. Mr. Choker.
My lords and my lady, ground 3 principally distills down to the 2019 strategic assessment of the NCA. And if I could take my lords and my lady to paragraph 110 of the judgment of the IPT, which is at page 314 in the core bundle, 314 paper, 316 PDF. In the judgment, the full, the full paragraph is quoted, and this is an assessment not in the published 2019 NCA assessment, which dealt with encrypted communications in more general terms. This is a confidential version of the 2019 assessment, which was provided after Mr. Wayne Johns had given his evidence, and Mr. Johns was the principal witness on the bulk point. This particular confidential assessment has substantial importance, because if one then goes to paragraph 136, which is page 320, their lordships say, on that analysis, the claimants can succeed in challenging the issue of a TEI warrant on the basis that a bulk equipment interference warrant should have been sought only if they have a proper basis for undermining the NCA's assessment. Their lordships go on to say the assessment dates from 2019 and was still current at the time of the application. It had not been created for the purposes of the application. So that 2019 confidential assessment is the principal factual issue upon which the IPT relied in relation to this particular ground. The assumption that's made in the judgment, and we say that it's nothing more than a speculative assumption, that it was not created for the purpose of the application, is one which is contrary, we suggest, to reason. the NCA knew from 2018 onwards that the French were investigating the servers at Roubaix, and from 2018 onwards, the NCA were involved in close cooperation with the gendarmerie, which included, and this was all in evidence before the IPT, including Mr. Shrimpton, the NCA's principal technical officer, travelling to France, providing assistance to the French in relation to modelling the servers. In 2019, providing test handsets to the French so that they could experiment upon them. In February 2019, official minutes from Europol indicating that the intention was ultimately that communications could be decrypted and obtained from the server. So there was at least a year's worth of clear indications to the NCA before the confidential assessment was published as to what the French, and for that matter the Dutch, who are included in the Europol minutes, were planning. And in addition to that, and again this was in evidence before the IPT, by January of 2020, thought was being given to deploying the NCA's own implants, their in-house implant, as it were, which Mr. Shrimpton and Mr. Elliott had devised. And that was a project which had been ongoing for a year. So there were multiple reasons why the NCA were expecting there to be some activity that related to either interception directly from the servers in France or interception from devices. And they had been working jointly with the French and the Dutch for nearly 2 years. Additionally, there must have been a reason why this particular paragraph was not included in the public version of the 2019 NCA assessment. And the most logical explanation for it not to be included is that the NCA did not wish to tip off users of EncroChat that interference was on the horizon. And it's difficult to consider any other rational basis for this particular paragraph to be omitted from the published version, other than the risk of tipping people off. So this is an issue which assumed substantial importance in the reasoning of the IPT, in particular the finding that the assessment was not created for the purposes of the application. If one wished to be pedantic, I suppose it could be argued that it may not have been created for this application, but it was certainly created for an application which would have been extremely similar, either targeted interception or thematic equipment interference, but perhaps with a slightly different version of the implant. But certainly, so far as interception is concerned, interception that was for the purpose of obtaining messages sent and received by EncroChat users. So the whole of the assessment made by the IPT in relation to the factual basis for applying for TEI rather than bulk really distills down to nothing more than an assumption. And an assumption, we suggest, that if it had been part of the evidential part of the IPT hearings, would be an assessment that was clearly created on the basis that it was expected that very soon there would be interference taking place, which would enable bulk messages sent to be analysed. So we suggest that that finding by the IPT, which is a finding based on prospective assessment, is an assessment which the IPT could not reasonably have found. It's a finding that no reasonable tribunal could find, that it's not an assessment created for the purpose of an application. The IPT, it would seem, have found that it was an assessment created for some other purpose, but haven't identified what the purpose was.
Is that the point of law for this argument?
The point of law relates to Article 6 and the right to a fair trial. The only...
No. I didn't make myself clear. There's only a right of appeal to this court in relation to points of law. I understood you to be saying the point of law you're seeking to argue is that the finding made by the IPT was one which no reasonable tribunal could make. Is that right or is that wrong?
We do say that it's a finding that no reasonable tribunal could make, but the point of law relates to Article 6 and the right to a fair trial, because the finding was a finding that was made without any adversarial process, because this assessment was submitted after the evidential part of the IPT hearings, and that deprived the complainants of any ability to cross-examine on this issue. And so the point of law is that the claimant's Article 6 rights were breached as a result of the IPT placing the utmost reliance on an assessment which was never adversarially scrutinised. And the reason I've set out the material which suggests that this particular finding is a finding that's likely to be wrong is to demonstrate that this isn't simply an academic point about Article 6. It's an Article 6 point with substance behind it, because it turned out to be one of the determining points that the IPT found, and it was a point that was made without any ability to cross-examine on this issue or to assess whether this was an assessment that was made purely for the purpose of warrantry applications in the future, and therefore was a tendentious assessment rather than an assessment that was necessarily genuinely held at the time. So the point of law is, we suggest, Article 6. My lords and my lady, could I just touch on a point that my learned friend Mr. Lacker dealt with briefly? It relates to the question asked by my Lord Justice Dingemans in relation to investigation or operation. We would respond to that slightly differently and suggest that the question as to whether this is a single operation has to be answered not in the context merely of linguistics as to whether it's an operation, but it has to be answered in the sense of context. And the context is what is an operation in the ordinary sense of law enforcement agencies, such as the police or customs and so on, because clearly this is legislation which is framed with such investigations or operations in mind rather than operations generally. And so far as Venetic is concerned, it's not a coincidence that it was rebadged from Project Venetic as Operation Venetic shortly before the warrant was applied for. The question of an operation should be an easy question to determine, because so far as the police are concerned, so far as customs are concerned, or so far generally as the NCA are concerned, operations have clearly defined limits. So the police would not set up an operation which relates to all drug trafficking in the UK, or all turf wars in the UK, or equally the Greater Manchester Police, if they set up an operation in relation to a particular turf war, there might be a number of investigations within that operation, but it would be within clearly defined parameters. And the police would not suggest that once they have set up an operation that relates to turf wars, that operation is then good for the next 2 decades, because there's turf wars that might emerge over those 2 decades. There would be a new operation set up. So those who deal with operations have a clear understanding of what an operation is, and that understanding of what an operation is certainly not an investigation into a whole subject matter, such as drugs, communications, organised crime. If the test is merely a question of badging, so that as soon as the NCA suggest that we're going to call it an operation rather than a project, when we look into EncroChat, therefore we can apply for a TEI rather than a bulk warrant, it means that the distinction which Parliament intended between bulk and TEI is no longer a statutory distinction. It's a distinction which is dependent entirely on subjective linguistics and whether the police or the NCA decide to call something an operation or a project. And that can't be what Parliament intended. It can't be that it's simply a matter for a senior officer to decide whether he or she wishes to call something an operation. It must mean an operation in the usual sense, which all law enforcement agencies are familiar with. If it's as simple as calling it an operation, putting a bolt on and downloading everything, then all of the protections in relation to bulk interference warrants are entirely pointless, because everything could be done through TEI. And if that is the position, it will have drastic effects on law enforcement, because it will send a clear message that from now on, bulk effectively, the bulk parts of the IPA can be ignored, because all that is required is for a senior officer to say this is a single operation, because the subject matter, the criminality is broadly the same, because it's all drugs, or it's all communication, or it's all turf war murders. Therefore, everything can be obtained and housed under TEI, because it's badged as an operation. So that we submit is an important public principle, and one that deserves further argument. And therefore we submit that leave should be granted in relation to the bulk grounds of appeal.
Thank you. Yep, thank you very much. Yes.
May it please my lady and my lords, may I trespass on the court's and respondent's patience just for 90 seconds? Again, to return to the question my Lord asked of Mr. Lacker, King's Counsel, concerning the single investigation point. And I hope I do it justice by...
Sorry, I'm terribly sorry. For whom are you acting?
Shergill.
Right, thank you. Yep.
The question was, isn't the single act of putting a bolt on the EncroChat system capable of being treated as a single operation? My learned friends for the respondent will confirm that at a case management hearing on the 8th of December 2022, Lord Justice Edis said we are prepared to approach this case on the basis that the statutory construction contended for by the NCA is a novel one. That was an echo of an email which the NCA officer Emma Sweeting sent its item 111, where she said, "We are likely to seek a thematic TEI warrant. This will by its nature be deemed novel and contentious." The National Crime Agency argue that there's no ground upon which this court needs to consider. This is an application hearing, and we respectfully submit that further arguments are required, based on the axiomatic fact that even the tribunal considered this to be a novel construction. So I hope that's within my 90 seconds.
Thank you very much. Yes, Mr. Perry.
Thank you very much, Lord. Our essential submission is that none of the grounds of appeal has any arguable merit. The Section 9, the Section 10, and the single operation arguments have been comprehensively addressed not only in the decision under appeal, but also by the Court of Appeal in A, see Authorities Bundle, page 394 to 396, and also by the Court of Appeal in Atkinson, see Authorities Bundle, page 442, paragraphs 118 to 120. And the remaining arguments, that is, lawful purpose, Article 8, criminal use of the platform, either collapse into the other arguments or are, on analysis, really issues of fact. They do not raise any issue of law at all, and certainly no important point of principle or practice so as to justify an appeal, and there is no other compelling reason for granting leave. The starting point we would respectfully submit to the court is, first of all, the jurisdictional basis on which this court would be entertaining these applications, and that's, as the court is familiar, Section 67A, and I won't turn it up, I'll just provide the references if I may, which is Authorities Bundle, page 12. As your Lordship observed in argument, it is restricted to points of law, and neither the tribunal nor this court is to grant leave to appeal unless it considers that the appeal would raise an important point of principle or practice, or there's another compelling reason for granting leave. The reason why we mention that is that this is a deliberately stringent standard. It reflects the fact that the tribunal itself is constituted by members with significant expertise and seniority in this field, and is intended to ensure that judicial resources are expended only in circumstances where leave should be granted in cases of sufficient merit. the statutory threshold has particular relevance in a case such as the present, where the issues have already been litigated to Court of Appeal level, and that the most significant consequences for the individual complainants arise not from these proceedings, but from their criminal proceedings in which the admissibility arguments have been deployed. So far as ground 1 is concerned, section 9, we rely on the Court of Appeal's decision and reasoning in A. The argument in relation to section 9, as the Court of Appeal noted, would lead to an extraordinary outcome, as it was expressed by the court. It would in fact inject incoherence into the scheme for the simple reason that legality under section 10.2a and section 1c little 1 would be swept aside and rendered unlawful by the overarching operation of section 9. That's simply incoherent. That is why the Court of Appeal conducted a conventional statutory construction exercise. It looked at the provisions on their face and in their statutory context and concluded that section 9 was to be read coherently with section 10. That was the conclusion of the Court of Appeal. It was also the conclusion of Mr. Justice Dove. The Court of Appeal approved Mr. Justice Dove's reasoning, and the clear intention of the legislature was to prevent circumvention of the regulation of Part 2 activity, that's targeted interception, to prevent the circumvention of Part 2 activity, targeted interception, and it simply operates on the basis that section 9 would replicate in a mutual legal assistance case the domestic position. You can't outflank the requirement for a domestic warrant in the same way that section 10 replicates the domestic position where it's a TEI warrant. That's the position. So section 9 had no application to this case. The tribunal, in the decision under appeal, agreed with the reasoning of the Court of Appeal at paragraphs 98 to 99 of the tribunal decision, but it gave its own additional reasons for doing so, which we respectfully contend are correct, and we invite the court to adopt them. We invite the court to reject the suggestion that the tribunal decision is based on any error of law, and or that this argument has not been settled by an authoritative decision of the Court of Appeal, albeit in the criminal division. So far as the lawful purpose point is concerned, ground 2, the argument is that the warrant was not lawfully obtained as it was obtained for a purpose beyond its lawful scope. The tribunal, see paragraph 78, expressly addressed the purpose of the warrant. It was to render conduct lawful when otherwise it might have been an offence under the Computer Misuse Act 1990, which the NCA might therefore commit as a secondary party by encouraging it. And our submission is that that is the classic lawful purpose of a warrant, to cloak with legality conduct or an operation that might otherwise involve some form of illegality. All the tribunal was saying when it made reference to section 99(5)(b was that to authorise conduct by requiring an overseas authority to act in a particular way did not sit comfortably with the particular facts of this case, but it was not saying that section 99(5), or for that matter, section 99 did not apply at all. Section 99(5)(a) is a form, as my Lord Justice Dingemans observed in argument, is a form of ancillary powers provision commonly found in legislation. The warrant authorises the conduct identified in the warrant, and 99(5)(a) makes clear that if you have to do anything else that's necessary to carry out the conduct, you have the power to do that also. The tribunal accurately analysed the provisions of section 99. It was consistent with what the Court of Appeal had said in A, and neither the tribunal nor the Court of Appeal in A needed to go further. The response to this ground in the tribunal's decision refusing leave, it's at paragraph 8, page 337 of the core bundle, the tribunal found that the purpose of the warrant was to render conduct of the joint investigation team lawful when otherwise it might have been an offence, and as the tribunal succinctly stated in its decision, that is not an improper purpose. And so we adopt the reasoning of the tribunal refusing leave in relation to this point. For the court note, if the court wishes to look at the schedule of conduct, which was actually the conduct in the warrant as opposed to the application for the warrant, that's set out at page 67 of the supplementary bundle. It effectively replicates the conduct in the application, but that's just for the court's note. Ground 3, section 10, we can address shortly. The tribunal found it lacked jurisdiction to consider the legal challenge to the European investigation order, and also found that had it had jurisdiction, it would have found the substance of the challenge lacked merit for the reasons given by the Court of Appeal in A. We respectfully submit that the tribunal's decision betrays no error of law. The tribunal had held that the making by the Crown Prosecution Service of a request for access to data obtained by the French authorities did not require the authority of a warrant under Part 5 of the 2006 Act, and it was not done under the purported authority of any such warrant. In other words, the Crown Prosecution Service act of making the request was not challengeable circumstances within the meaning of section 65(7) of the 2000 Act. For the reasons which the tribunal gave, we submit that that was unarguably correct. So far as the bulk and thematic warrant arguments are concerned, there are three arguments as summarised in the tribunal decision refusing leave to appeal, see page 338. Ground 1, the single investigation or operation within the meaning of section 101(1)(c) of the 2016 Act. We respectfully submit that this was really a finding of fact. The IPT concluded, see paragraph 132, the operation was one to obtain material from one source, namely the EncroChat system, and it was material about a large group of people who were all users of that system. The IPT also found that the language of section 101.1c is clear for the reasons that it gave, and we respectfully submit that the arguments to the contrary on analysis raise no arguable point for consideration by the court in a full substantive appeal. The Article 8 point collapses into the Section 101C point, because if it's a question of fact and you're within the scope of the statutory scheme, there's no freestanding Article 8 argument, and the tribunal was correct in its approach in relation to that. The exclusive criminal use point, the tribunal's findings were also in relation to this essentially findings of fact, and also in relation to the point that was made by my learned friend in relation to Article 6. The short answer to that can be seen by reference to the supplementary bundle and the application for the warrant, where at page 529 of the bundle, reference is made to the NCA Strategic Threat Assessment 2019 and the exclusive criminal use point.
Sorry, can I just try and pin down this page?
Yes, 529, my lord, in the supplementary bundle, I hope.
Yes.
And it's at the box at the bottom of the page.
Yes, thank you.
And it's where there is reference to the 2019 Strategic Threat Assessment, concluded the platform is used exclusively. It's also relevant to note that we were before the IPT in proceedings which were conducted, I think, over more than 8 days in the end. These proceedings took place over more than 8 days. And if I may just finally refer the court to the tribunal's decision in relation to the argument in relation to exclusive criminal use, because the court has been referred to the point being made about the 2009 assessment. That's at page 320 of the bundle. But it's also relevant to see what the tribunal went on to say about the material which had emerged subsequently, which they said was irrelevant because operating on judicial review principles, but they nevertheless went on to address it, does in any event not show non-criminal use of the system. It shows very extensive use, and it goes on to deal with that. And without turning it up, the court will see the cross-references to paragraphs 111 and 112, that they're references to the evidence that had been given by Mr. Johns, who was the senior investigating officer and also the person to whom the warrant was addressed. And paragraphs 110 and 109 also refer to the strategic threat assessment and the type of warrant. So this was carefully considered in relation to the particular type of warrant that was required. The evidence was clear before the tribunal. No arguable breach of Article 6 arises. And the arguments were in fact all addressed in the decision refusing leave to appeal, and we would invite the court to dismiss this application on the basis that there is no arguable merit in any of the particular grounds. But, Lord, unless I can assist the court further, those would be our...
Can I just ask, as a matter of chronology, so when did the document referred to in paragraph 110 actually come into the hearing?
Well, my Lord, there was some evidence about the 2019 threat assessment, and then I think we had a second sequence of days before the tribunal in December, and I think it was in the course of those proceedings. We'd have to put, to be precise, my Lord, I'd have to nail that down. I don't want to just do it and say
And did
something.
anyone ask to bring back Mr. Johns to be questioned?
Well, I think there were lots of requests for Mr. Johns to come back and question, to be frank. But the thing was, we went round this course in pretty exhaustive detail. And it's also been dealt with in all of the various Crown Court proceedings. And it wasn't the first time Mr. Johns had given evidence and been cross-examined, nor was it the first time that Miss Sweeting had. But the suggestion that the tribunal somehow acted unfairly when exercising judicial review principles on a legal challenge to a warrant, we would invite the court to say has no substance whatsoever.
Thank you.
Thank you very much.
Thank you.
Yes, Mr. Ryder.
Just to deal with some short points in reply. First of all, I mentioned in our submission that we would provide you with the document where the Court of Appeal Criminal Division refused to certify a point of public importance.
Yes.
Which we submit assists in understanding what they believe to be the ground of their decision. I think my own friends now have copies. May I hand these up?
Yes, that'd be very helpful. Thank you.
And this is in R&A, is it?
I'm sorry?
R&A?
Yes, my lord.
Yeah, thank you.
Yes, thank you to whoever's organised a copy of this whilst we've been conducting the hearing.
I apologise that this wasn't brought to you earlier. The over the page, the second page, the section 4 point, if I can put it that way, that's not before you now, was described at paragraph 5 as the decisive question. And at paragraph 6, the Court of Appeal Criminal Division said that it's clear that decision on the other issues were not essential to the decision in the case. And then those are the points we wish to make on that document.
Thank you.
In answer to, I also said I would just mention the reference to the difference between the criminal jurisdiction and the civil jurisdiction, or the IPT's jurisdiction, when it came to assessing warrants and how the courts are in a different position. The reference, helpfully, and Mr. Cash has helpfully brought it up for me, is the authorities bundle tab 12, case of Atkinson, page 443, and it's at paragraph 121 to 123, where Lord Justice Fulford explains how it's not possible to challenge the legality of the warrant in a criminal court, and you must do that in the Investigatory Powers Tribunal. And it is for that reason that we say the criminal courts are hamstrung by having to proceed on that basis, and therefore they start with saying the TEI warrant is lawful and have to work the rest of the submissions around that, whereas the IPT should have approached it differently. But yes, that reference, paragraph 121 to 122.
Thank you.
In answer to my own friend Mr. Perry about section 9 and section 10 and how our submissions would make those provisions incoherent, we simply say this: it's important to be aware that Section 9 and 10 perform different functions, very different functions. Section 9 is a general privacy protection for a specific situation where the domestic authority needs to have a particular warrant to make a request of a foreign agency to do the unusual step, one may think, of interceptions within the UK, or to people going to and from people in the UK. Section 10 is very different. It is the provisions that accompany an EIO or a mutual assistance request, which can be for anything. It could be for the product, as it was in this case. They are completely different provisions, and it's not surprising there would be different warrantry. In fact, in this case, they do reflect the two requests of the French, one to get lawful authority to do the interceptions, two, an EIO for the product. There is no incoherence, and it is wrong in our submission to suggest there is, to apply Section 9 as we say it should be applied in this case. In relation to paragraph 78 and paragraph 108 of the ruling by the tribunal, this is to do with ground 2. The section there that says the purpose of the warrant was to make something lawful. It has to be read in conjunction with 108, which is, despite Mr. Perry's way of approaching it, not something that one can simply dismiss as a question of fact. It isn't. Paragraph 108 is a statement of legal principle about the applicability of that provision, 99.5b, to this situation. It is expressed in firm terms. It has no application relation to the assistance that a foreign state may provide. It is not restricted to the facts of this case. It is put in those broad terms after what is some lengthy discussion in the preceding paragraphs. It really amounts to two possibilities. Either, as we submitted originally, Section 99.5b has no, the IPT is right, the Section 99.5b has no application to request for a foreign agency, in which case their finding in Section 78 is a finding of the effect of the warrant without any conduct being authorised. And I'm grateful to my learner friend Mr. Perry for highlighting that the authorised conduct at tab 3, core bundle, page 67, includes reference to Section 99.5b. It is specifically included in that conduct that is supposed to be authorised, which is in contradiction to the provision in paragraph 108. So either our submission I made earlier is correct, or the IPT have found in Section 78, as I understand Mr. Perry to be submitting, that the IPT found that to be the purpose, and it was consistent with the warrant, in which case it is completely inconsistent with paragraph 108. It doesn't sit at all with paragraph 108, and paragraph 108 contradicts that, because the warrant can't authorise the conduct, according to paragraph 108, that it would have needed to authorise to make paragraph 78 have effect. So one way or the other, those two paragraphs cannot sit with each other. They are statements of legal principle. Well, 78 is a statement of the interpretation of the warrant, which is a matter of law, but 108 is certainly a question of law. And as a result, they cannot sit together, and there's a conflict there. The only other point I would make in probably the minute I have left would be in relation to the submissions, the way Mr. Perry approached our submissions in relation to Section 10. And can I just take you very quickly to our skeleton argument? It's at core bundle 1. And it's page 87. Paragraphs 56 to 62. And Mr. Perry, I think, characterised those as being points that had no merit. And the first point to note is that, as I understood the submission just made a moment ago, I may have misunderstood them. It is important to be clear that there should be no dispute between us, that if the submissions made here from paragraph 56 onwards about the need for a mutual assistant warrant are correct, then there can be no dispute there was jurisdiction. They are not two separate matters. If a warrant was required, there is jurisdiction. That's clear from the IPT's finding. It's because they found against us on the merits, they found that wasn't a basis for jurisdiction. They're not separate. But in relation to that, just quickly, because it may be in the rush of points become slightly lost. At paragraph 57, we explain that there was an amendment to section 10, and it was to give effect to the 2017 regulations. Paragraph 58, we explain that the directive was, the purpose was requiring the issue authority to determine that the measure requested was one which could have been ordered in a purely domestic situation. And we quote, the issuing authority may only issue an EIO where the following conditions have been met. And B, the investigative measure indicating the EIO could have been ordered under the same conditions as a similar domestic case. So it is to have a parallel regime of what the power could be in a domestic case can be ordered under an EIO, which is what 10.2 goes to. Paragraph 59 reinforces that in the regulations under the same conditions in a similar domestic case. In other words, it is seeking to ensure there's equivalence of domestic authorization. And it's against that legislation, it's paragraph 60, that 10.2 and 10.2a came into effect. They are consequential amendments. And 61 sets out how this would have caused a problem if the exception in 10.2a hadn't been included, because there are specific wording in section 6.1c that includes a statutory power as being a basis for obtaining stored communications. It always has within the context of REPA and IPA. Statutory power can be a basis for obtaining stored communications. And what is intended in this provision is to reflect that in 10.2a, and therefore one can simply see that the statutory wording that appears in section 6.1 is replicated in section 10 to ensure that the same statutory power is dealt with, leaving out the TEI warrant. So at 62, our paragraph 62, when one analyses that, one can see that the 10.2a is designed as a mirror provision. And at 63, we say what is meant by a statutory power that is exercised for the purpose of obtaining information or to take possession of a document or other property. In other words, the phrase in 10.2a is really that it sets out, and it's made very clear, and we give reference to it, Interception and Communications Code of Practice, the supplementary bundled paragraph, it's at the bottom of paragraph 63. There are a number of statutes, and Lord Anderson set this out in his A Question of Trust report. There are a number of statutes that set out what those statutory powers are. That is the statutory power that is being referred to in section 10.2a as coming within an exception which a mutual assistance warrant is not needed under section 10.2. It is not a self-authorising position where the statutory power of the EIO becomes its own exception. Finally, there was a point that was mentioned to me, and I referred to it in submissions earlier, to do with the authority for which I relied to make good the proposition of an exception to the, or to a residual discretion over and above that which is there in Young. And Mr. Perry referred initially in his early first submissions to the issue of precedent, or that it's been decided in other courts. The reference that we would rely on, I apologise for not putting this authority before the court earlier, and so I will, of course, I'm happy to provide it to my learned friends, and I apologise that it's not been provided earlier. But I did mention earlier the case of Hayes, which is the neutral reference is 2024 EWCA CRIM 304, and it's in the criminal appeal reports at 2024 2 criminal appeal reports.
Sorry, ECWA CRIM
304.
Thank you.
And it's a decision of Lord Justice Bean, Lord Justice Popwell, and Mr. Justice Bryan of March of this year. It's to do with libel and whether subsequent rulings in relation to libel should cause an earlier Court of Appeal decision to be revisited. But helpfully, for our purposes, and I do no more than reference it, the court there, in giving judgment at paragraph 84 to 85, I have a copy. I can hand up copies, but I'm afraid and I know my learned friends haven't seen this, so I do apologise. It's just to show the reference, because when asked what authority we rely on.
Thank you very much.
Just quickly, it's at page 140 at the top left-hand corner, paragraph 84. The court there considers the case law on the doctrine of precedent between Court of Appeal decisions and sets out the principles there. My Lord, I should make clear we accept and we don't dispute what may be settled law in relation to the principles that are set out by the court in that case. We're not seeking to make detailed submissions on them. They are the principles. They include a residual discretion in the context of criminal cases, and we submit by analogy that should apply here. But our fundamental point, and sorry, I should also indicate, we accept that it should be exercised sparingly. But we make two really fundamental points in relation to this, my Lord. The first is simply that because of the different roles, and I've said this before, the roles that the IPT and the Court of Appeal Criminal Division were in, they are not analogous to a precedent that is dealt with in a identical consideration by the Court of Appeal and what will be considered or would be considered if we were given leave to appeal. They are different contexts. So in a sense, this doesn't apply. The need to have an exception to Young doesn't apply if we're right about that in our submission. And so in relation to that, our fundamental point on precedent is that they are different. But if we're wrong on that, and if we do have to have a discussion in this case as to whether this court should consider departing from the decision in A, as I've submitted earlier, we submit that should be, and we respectfully request that would be best heard in full argument, rather than to be a reason for not granting permission to appeal now. I'm grateful for the time.
Thank you.
Lord, I don't have anything to add to the submissions I made. Can I give one reference there that I promised, and that was to the EIO application and the terms in which it was drafted, and that is in the supplementary bundle at page 36, and it's at the top of the page.
There are a number of different numbers on this in the supplementary bundle. I got 36, 33.
That's the one, 36, 33.
That one.
Yes.
Fantastic.
And it says at the top, in addition, it is proposed in the first instance to create and disseminate intelligence packages, etc.
Yeah. Thank you very much.
Thank you.
Well, Lord Summerlady, could I deal with the chronology point in relation to the National Strategic Assessment, the sensitive version rather than the public version? There were questions raised about the provenance of that extract, which weren't resolved until the 20th of December, which was after the second tranche of hearings. The main evidential hearings were earlier in the year. Then there were 3 days set aside in December, principally for submissions, although the claimants were successful in having Emma Sweeting recalled, but no other witnesses recalled. And then after the December hearing, the final hearings, there was an email from NCA Legal dealing with the provenance. So there was no opportunity to deal with the issue of whether it was an assessment created with an eye towards warrantry as opposed to freestanding. We do suggest that because it has such importance, there must be a compelling reason for that to be considered by the Court of Appeal, because it's difficult to conceive of any other reason for it other than warrantary. Otherwise, it would have been in the 2019 public assessment.
Sorry, I'm not quite following this, Mr. Joker. The paragraph itself was the subject of discussion at the hearing before the IPT, was it?
My recollection is that it was part of the discussion in the submissions in December, where there were questions about the provenance of it, which were resolved after the hearing.
But provenance is one aspect of it. But surely you had the opportunity to ask questions about it if it was before the IPT. I got the impression from your earlier submissions that you just knew nothing about this paragraph at all until after the hearing. But if the only question is what you call the provenance, what was revealed about the provenance which wasn't known before?
We had the 2019 public version,
Yes.
which made similar points in relation to encrypted networks designed for criminal use, but not specifically EncroChat.
Yes. But you, I'm afraid I'm getting thoroughly confused. It's probably me being slow. Did you or didn't you, when you were before the IPT, have the confidential paragraph?
We didn't have it. We had the part that was included in the TEI application, but not the paragraph itself. We didn't have the sensitive assessment, and we were provided with that after the evidential phase. There was a further question about the provenance of it raised in submissions because we had been refused permission to have certain witnesses recalled.
But how were you raising questions about the provenance if you didn't have it? You didn't know it existed. How could you be asking about its provenance?
Because we'd been given the extract, and we were given the extract, from my recollection, between the evidential hearings and the legal submissions. There were then questions raised in December about the provenance of that, which were resolved on the 20th of December.
Terribly sorry. Can you just show me somewhere in the papers the relevant paragraphs so we can identify what you did have and what you say you didn't have during the hearing itself?
We simply had, after the, this isn't something that I dealt with evidentially because the tasks were divided up, so my recollection may be wrong, but my recollection is that we had the extract, which
but
is
please give me a
quoted.
page. Give me a page I can look at, Mr. Joker.
It's paragraph 110 of the judgment.
Right, thank you.
Just that paragraph.
So you had that?
Just that paragraph.
Right.
And my recollection, I may be wrong, but my recollection is that that paragraph was provided after the evidential part of the hearing.
And before that, you had a cryptic reference to this paragraph in the application itself.
Yes. Yes. Which wasn't inconsistent with the public assessment, but that was in general terms about encrypted communications designed for criminal use.
Thank you.
Right, thank you very much. That's very, very helpful.
Lord, I'm sorry for one final point. I've been asked on behalf of all appellants to just mention one point. As you know, these are 11 applicants who essentially are bringing representative proceedings after a number have also been stayed. The intention when leave was applied and what happened when leave was applied from the IPT was that each of the claimants adopted each other's points on the basis that if leave was given on one or other point, then each of them would benefit from that. That hasn't happened in relation to the wording of the grounds. So it may be, although that is, I think, the intention, and I've been asked to raise it on behalf of all claimants that all points are cross-adopted, it hasn't been reflected in the grounds. It may be that you would wish us to put an application in writing in relation to that and have submissions to the contrary, or whether you feel able to give us permission for that now, but that's it.
No, I don't think so. I think we've been proceeding on the assumption that if a particular point was made by one of you which found favour and was applicable to others, that the fact you hadn't formally jumped up and said, I adopt that as well, I don't think would count against you.
I'm obliged.
But
and
thank you for
I've asked to
raising
raise it. Thank you, my lord.
Right.
My Lord, may I,
Yes, Mr. Perry.
May I mention one matter? My Lord, this morning when the cry went up for hard copy bundles of the authorities, we prepared a copy, and I don't know whether it would be of assistance to any of you lordships to have a hard copy of the authorities.
No, I think there is uniform contentment on the bench as to the provision of copies, whether paper or otherwise.
Thank you very
But
much.
thank you very much for the offer.
Thank you.
Right, well, we'll just rise for a minute or two to see where we're up to.
Court rise, able.
Thank you very much.
I would like to remind the court that the live stream is still running, so any conversation you have, you can take them outside.
Thank you. Yes, yes, don't go into it. But I think
Definitely after the approach.
Court rise if able.
It's all right. Thank you very much. We're very grateful to Council for the submissions we've received supplementing the oral submissions. We are going to reserve our decision. We will hand it down in writing as soon as possible, though we can't predict quite how soon that will be. In advance of what we expect to be a remote handing down, we will provide a draft to Council for assistance with identifying any typographical or other errors, and for assistance in drawing up any necessary order. That will be on the basis that the draft is limited to Council only, but on the footing that they may communicate the substance of the judgment to professional and lay clients not more than 2 hours before the time fixed for remote hand-down. If it transpires that any further hearing is necessary in the light of the decision when handed down, well, we'll consider that at the time. Right?
thank you.
Thank you all very much indeed.
Court rise if able.